Supreme Court has officially ruled against the Trump administration in their bid to end the Obama-era Deferred Action for Childhood Arrivals programs, also known as DACA, shielding so-called dreamers. Here to give us the latest is Jimmy Hoover, Supreme Court lawyer over at Law 360. We want to roll up our sleeves here, Jimmy, dive right in. Thanks for taking the time. Look, it was a 5-4 ruling, but it did not necessarily say that the Trump administration couldn't overturn DACA, basically just saying they went about it the wrong way. What stands out to you based on what we've seen from the high court this morning?
Just a quick point of clarification, Supreme Court reporter, not lawyer, because I know there are a lot of lawyers that know a lot more than I. But to answer your question, what stood out to me was that Chief Justice Roberts once again has joined with the liberal justices to block a very controversial Trump administration policy on the grounds that they did not provide a good enough policy rationale. This obviously being the same case last term in the citizenship census case. So that definitely stood out to me. But as you're right, I think a big takeaway here is that Chief Justice Roberts says, you know what, everyone here agrees that the Trump administration legally can rescind DACA. The question is about the process, about how they do it. And here he concluded in his opinion for the court that the Trump administration did not follow the proper process in rescinding DACA. It had to go back to 2017 when the Trump administration laid out the rationale for when it actually pulled the rug out from underneath this program. And the original rationale, that memo that then Acting Secretary Elaine Duke wrote in September of 2017, Chief Justice Roberts concluded on behalf of the court's majority that that was not a good enough rationale. It was pretty bare bones, and basically it had just said that we have to do this because it's illegal. But Chief Justice Roberts, in his opinion for the court, he says, Duke's memo did not recognize the amount of discretion that she actually had as the then acting Secretary of the Department of Homeland Security in order to wind down DACA. And also, she didn't address at all the reliance interests of the 700,000 so-called dreamers that were recipients of this program who had planned their lives around it, et cetera. And so a belated explanation that came 2 months later from her successor as the head of the DHS, Kirstjen Nielsen, going into a little bit more details about why the Trump administration was doing that. Chief Justice Roberts, writing for the court, said that wasn't good enough. It's basically a post hoc rationalization.
You're exactly right. Imagine being Elaine Duke this morning. Your name's in the headlines for all the wrong reasons. I do want to ask you about part 4 of the Roberts opinion. This, to me, is the most fascinating part. It shows Justice Sonia Sotomayor as the only person here, Jimmy, who thinks there was intent from the Trump White House. That's the important word, intent to discriminate against Latinos. But all the other liberal justices disagree. So this rejection is 8-1. How significant is that? What should people understand about those dynamics?
I think it's been a theme that we've seen throughout the Trump administration, especially Justice Sotomayor's willingness to kind of essentially call out some of these animating motives of racial animus, religious animus. We saw it in the travel ban case as well. But Chief Justice Roberts, I guess, wanted to have a very narrowly focused procedural ruling saying that, while the administration can do this, we, again, disagree about how it went about doing this. This obviously inspired, in addition to the dissent by Sotomayor, or she dissented in part, I should say, to that point about the Equal Protection Clause. You also had the dissent by two dissents by Justice Brett Kavanaugh and Justice Clarence Thomas, who said that the Trump administration can, of course, wind down this program. They were slightly different reasons for why they had concluded that. Basically, Thomas said that the Duke memo was totally sufficient to wind down this program, whereas Kavanaugh had said that, the Nielsen memo just a few months later took care of it. And so they reached slightly different conclusions. But you're right, it was a very fractured ruling. It took, the Supreme Court press corps like myself a couple minutes to kind of figure out who joined what. But, immigrant groups are celebrating this as a pretty broad, I shouldn't say broad, but it's a pretty big victory for the 700,000 dreamers in this country who now have a little bit of temporary relief. And I want to emphasize temporary here, because the Trump administration could potentially go back and cure some of these administrative defects that Chief Justice Roberts found in his majority opinion.
Yeah, I think temporary is the key word. Just Clarence Thomas saying today's decision must be recognized for what it is, an effort to avoid a politically controversial, he noted, but legally correct decision. Jimmy Hoover, Supreme Court reporter over at Law 360,